going to the courts, Ayo, while we're looking at examination malpractice, it does appear that the political parties also had an exam of some sort set for them by INEC, and they were not happy about it, so they went to the courts, and the courts gave them favorable judgment. Justice M.G. Umar has given political parties a judgment that has left them smiling by saying that all the timetables that are inconsistent with the Electoral Act and the Constitution are hereby null and void. The initial ruling was supposed to be about registration of political parties, but it certainly went beyond that and gave political parties a reprieve. And right here in our studios, we have with us Chief Peter Ameh, who is the acting national chairman, Coalition of United Political Parties. He's been grinning from ear to ear, I must say, about this particular judgment. But let me know, how big a relief is this judgment for political parties given by Justice Umar?
It's a very big relief because most of the regulations that were made by INEC for 2027 elections were inconsistent with the Electoral Act and some part of the Constitution. Because the National Assembly actually passed a crooked electoral law in order to design to undermine the participation of opposition political parties in the 2027 election. Look, this judgment is an impactful step. There's no doubt about it in reshaping our internal dynamics within political party management. Because clearly it states that the overregulation is not what we should be doing. There are already stipulated modus of operation for political party. INEC and National Assembly are not doing overreach by creating timeline that does not align with the procedure of the Electoral Act, Section 29, subsection 1, that says that political party will submit particulars of their candidates 120 days before the conduct of election.
20 days?
120 days.
120, okay.
That is about mid-September. Okay. You have now crashed this process. Yes, the timeline, the arrangement that INEC had, well, 6 months. People will finish their primaries by 30th of May. They will have enough time to campaign. But you have to be able to align it with the Constitution. What the White Youth Party have done, this is not the first time Youth Party is challenging INEC and they are winning. They were previously the register. They went to court and they returned. And we must commend them for their continued act of activism in deepening the political system and political participation. If you have a law that says that you will come to monitor Section 84, subsection 1, Section 82, that you will come to monitor primaries of political party, and political parties are always supposed to give you 21 days notice. That law does not extend to you prefixing timeline for the conduct of their primaries. It doesn't extend. It is the prerogative right of the political party to give you 120 days for the conduct of their primaries. For you now prefixing this other timeline, it means that you have taken away the function of the political party to determine its own internal affairs and processes. So these are the challenges.
So it does raise big questions, though, because we do know that INEC is the regulator of political parties. And as regulator, it should be able to stipulate, because if things do not go as planned, if the electoral process is not free and fair or anything goes wrong with the organization, the political parties will be the first to go to court and hold the commission responsible. Now, the commission is hoping that certain processes would have been done by a certain time to give it sufficient time to be able to get on with other processes. But it does appear that political parties are not satisfied or are not happy with this and have, have now tried to torpedo the process with this court judgment.
Please, will you look at the timeline at which INEC released its timetable? There was just 1 month notice to the political party. Even a student preparing for exam will have a long time to study. You have the electoral that says that substitution of candidate must be done 60 days before the conduct of elections. And the one that also says Section 29, subsection 1, that says 120 days primaries must be conducted. The INEC should not become a law unto itself. INEC is a regulator, a registrar, an administrative unit for management of political parties.
It did not create itself.
But the political party also did not create themselves. INEC is just an instrument of the Constitution for creating political party. INEC was created under Section 133 of the Constitution.
But
and those holding appointment are under
this is not me holding brief for INEC. But in all honesty, we have been here when people have said, let us unbundle INEC. That INEC as an institution is doing too many things. It has too many parts to itself. And that the way things are being done, we will continue to see levels of confusion. And then perhaps to forestall this? Since we have refused to unbundle it, since it's still one institution doing all of this many parts, I think one thing INEC has refused to take on is prosecution of electoral offenders, because they are saying that there needs to be an establishment to take on that, you know, primarily. Look, as we speak right now, I think it's next week that is Ekiti elections. And then we're still in the process and it's still the same institution that's going to conduct it. So are we really being fair to the institution with the expectations that we have of it, given the many parts that we know it also contends with?
Now, don't forget, I was National Secretary of IPAC for 2013 to 2015. I was National Chairman of IPAC. INEC has capacity. It is just that the beware of the parties in power that undermine the functionality and the operational competency of the commission. This law was made, crooked law was made by those in the National Assembly. INEC did not even, the proposal given to the National Assembly by INEC does not constitute any of this, it does not contain any of these provisions. So you can't just say INEC. If people talk about INEC being the creation of the law as established in Section 133, and INEC chairman enjoying his own provisions and all the appointees there in Section 155 or Section 1C, political parties also are the creation of the Constitution. They are established in Section 223 to 210. And how they will function, how they will operate, has also been defined by the Constitution and the Electoral Act as amended. So you cannot go back and then cook a law in order to twist the participation of deepening political party opposition participation in our 2027 election. What we are saying is that instead of expanding the space and creating inclusivity for multiplicity of political party participation, the National Assembly, through the tyranny of the majority in the National Assembly of the APC, are writing laws that does not align, that does not tally with the provisions of our Constitution. You know that anywhere any law exists that undermine the principles of our grand norms, these laws are null and void. Yes, INEC has the power to make regulations and guidelines. With the last one before this one was in 2022, for the conduct of elections, for the regulations of political party, because these are subsidiary legislation that are not superior to the principal law or act that covers the conduct of elections in Nigeria.
Well, I know that Ayo would like to come into this conversation, but I'm currently looking at, it's very interesting that the certified true copy of this judgment is already out, and I think that this is very commendable. First and foremost, you see a list of declarations in the judgment order as given. About 7 declarations are made, and then the orders following those declarations are then given, another 7 of them. So order is hereby, I'm looking at order 7 now. It says order is hereby granted, setting aside or nullifying the time frames imposed by the defendant in its revised timetable and schedule of activities for the 2027 general election for the conduct of primary elections by political parties. I know there's always a lot of repetition when you look at this. Just to be clear, sometimes you get this sort of repetitions within the orders. So it says the submission of personal particulars of candidates by their political parties for the 2027 general elections, the withdrawal and replacement of candidates by political parties for the 2027 general elections, the publication of the final list of candidates for the 2027 general elections, and campaigning for the 2027 general elections which are inconsistent with the provisions of the Electoral Act. What do you think that this particular order, what impact or import, shall I say, does it have on the conduct of the primaries that political parties are currently having? We have seen that political parties are right now in the middle of primaries, especially the All Progressives Congress. For those, there have been a lot of complaints, there have been fallouts. There have been those who are saying, oh, the timeline is too tight, people cannot defect. Because some people say, before now, if you're unhappy with how the primaries are conducted in your party, and you know that you're very popular on the ground, you can easily defect to another party, and you know have the people support you, because it is INEC that is conducting these elections. Does it give such a room, does this judgment give such a room for aspirants who are currently aggrieved?
Of course. What the National Assembly and INEC eventually is over-regulation. The brazen act of over-regulation to be able to stiffen political participation. And if you look at the judgment today, there's timeline and there's enough time. And INEC no longer have the powers of today to predetermine how parties are supposed to set their timetable for the conduct of their primaries within it's an internal working process of the party. This is a law, and how they select their candidate. That is the function. That's not the function of INEC. INEC is not a registered political party. So what I know is that right from time, friends and colleagues who have been around me, I've told them that even trying to conscript and reduce the political cycle in a way that undermine multiplicity and undermine interest of our people to freely move, as enshrined in Section 40 in the principle of freedom of association, is also an aberration to our law. Under any imperative strategic reasoning, it is clear that INEC should be unbundled. We have agreed. I agree with that submission. I've agreed and I've written about it since 2008, when Justice Way's electoral panel reform made those recommendations. We have had people who have come to power who think it is better serving their interest and protecting themselves in power. After 8 years, they leave office, they start to write books and think that INEC should be unbundled. Because INEC is overburdened by the activities of regulating political party, of registering political party, of carrying out delineation of constituencies, of running electoral tribunal and other related offenses regarding our elections, and a lot of other things. So you cannot have a such commission that sits just on Zamiza Street, does all of these functions, while we are supposed to unbundle. If you go to ordinary Sierra Leone here, or small countries, they are unbundling it. So the INEC will be responsible solely for the conduct of election in Nigeria. That will give them enough time, and also remove politics from their activity, and also give them the Department of Legal Services today can be transformed and be reorganized into one of the tribunals, so that they can work and be able to manage affairs. Look, today, how many people do you see that after they commit electoral crime and the government operating in the state, which we apply what they call the principle of nolli prosecute, to be able to determine and withdraw who goes to trial? Because you conduct an electoral offense in a state where somebody is a governor, and that offense was to favor him. He will tell his attorney general to withdraw because they have overriding interest to withdraw or to prosecute. So that also undermines the functions of INEC to be able to do. Yes, INEC have been able to successfully prosecute some of one or two persons. But if you look at the case, you will see that the people who were involved were eventually abandoned. We need to be able to have a transparent process of the conduct of our election, and also stop the overreaching tendencies of the Electoral Commission and those who are making laws for the good governance and development of the country. Instead of going in that direction, they are retrogressing to make laws to see how they can perpetuate themselves in power. Today, those who attempt to trap the opposition lawmakers who were promised automatic ticket and defected from their party in mass, against the provisions of Section 109, Section 1G, are now being trapped.
Well, so it does appear that the opposition parties might have their people back at this rate. But let's go to Lagos. I know that Ayo also has some questions here. Ayo.
Mawkwe, it's a very exciting conversation we're having, but I understand we've since been joined by Dr. Monde Ubani, who is a senior advocate of Nigeria, and he's also going to be speaking to us about this particular conversation we are having this morning. Thank you, Dr. Ubani, for joining us this morning. Please confirm you can hear me.
I'm hearing you, Ayo. Ayo, I'm hearing you. Morning.
Yes, good morning, and thank you for joining us. Let's begin with your take on that judgment that we are talking about now, the Justice Umar's decision nullifying INEC's deadlines that's just been released, and of course, conversations and reactions are already trailing it.
Yeah, it throws the transfer window open till September. You know, INEC gave a deadline to the political parties to submit the membership register on or before 10th of May. Now, in the light of this particular judgment that says that INEC guideline was clearly ultra-virus of the provisions of the Electoral Act, it then means that the political parties all have September deadline. It says 120 days before the election, you must submit names of your candidates. Now, INEC wanted to do this earlier, and I wrote an article in which I suggested that maybe because of some administrative convenience, and INEC wanted to get prepared and not want to be under any pressure whatsoever, and that's why they did issue a guideline that runs contrary to the provisions of the Electoral Act. And then a political party has to go to court in order to challenge that particular guideline. And of course, in consonance with the normal jurisprudence in Nigeria, that you cannot use a guideline to override a statutory enactment. There is already an existing law that gives you power to do certain things, but you must not do anything that runs contrary to the fundamental or the framework that gives you that power. If you do that, that will be declared null and void. And this is what the court did yesterday by declaring that guideline that actually shortchanged the political parties with regards to days within which they submit their candidates, null and void. That is the impression I have gotten about this judgment. He has thrown the transfer window open.
I like that you are also using my term, the transfer window. But then what are the administrative and operational consequences or implications of this decision? We understand that the elections are supposed to hold, what, in February next year? And if that is still...
January and February, yeah.
January and February. So if that is still going to happen, it practically means that INEC has very, very limited days to do what it has to do. So for you, from where you sit, as a legal practitioner who's been involved in elections, and I'm going to throw the same question to Mr. Peter Ameh, what are the operational and administrative implications of these for you? Particularly since the pictures of the candidates are not going to be on the ballot anyway.
Yeah, it's a practical question. But my problem with INEC is that INEC shouldn't wait until it is time for election to get prepared for the next cycle of election. INEC should always be prepared at every point. If you finish election, you know that the next election will be in 4 years' time. So all the things that you're supposed to do in terms of, planning for that election, except issue of timeline, you keep it open. So, but I agree that it took the National Assembly some time before they passed this current law. People were expecting this Electoral Act to be passed last year so that INEC will begin to get prepared and will not be under any pressure. Of course, eventually the law was passed sometime this year, and it put INEC under a very tremendous pressure, and that's why they were shortening the timeline for some of the things that they wanted to do, because, of course, the election would have started next year by either February, and then the gubernatorial will be sometime in March. But due to what has happened with the Electoral Act, which was passed very late, INEC now had to shorten some of these processes in order to accommodate their administrative conveniences, and that's why they may have done what they have done in the circumstance. So, but the law itself must not be sacrificed on the altar of convenience. Yeah, they will have some administrative issues and not to deal with, but then they should get back to the board, get on board and say, look, now that it has happened, what do we do? We are not going to in any way fail Nigerians. We must put this thing in order and ensure that the electoral process is ongoing. So I don't envy them, but they must obey the law. They must comply with the statutory enactment and not go against the statutory enactment that gives them power to do certain things and all that. I don't envy them, no doubt about that. There will be some inconveniences, but inconvenience and convenience must not be sacrificed at the altar of what is lawful.
Should have been part of that process. But Mr. Ameh, if you can hear me, Dr. Ubani said right now that INEC should start preparing for the next elections immediately after the current or the previous one. That begs the question whether or not even the political parties themselves shouldn't start the same. Because if it has to take if any political party has to wait until the tail end, so to speak, of any process to get its acts together, it begs the question whether or not they are ready for the election in the first place, Mr. Ameh.
Yes, I align myself with the position of the learned Sikh. He has stated things clearly. And the fact is that INEC should not be seen an election like an emergency piecemeal that they have to bring on board every time the election time draw closer. What INEC should do is to set up a parameter and create a framework that allow them to continue to have a template that is dependable, that they can rely upon to conduct election anytime election comes.
Just a second, Mr. Ameh. Just 1 second. Just 1 second. The question is, Dr. Ubani has responded to the one concerning INEC. The question is, the political parties, shouldn't they also get ready about the same timeline as INEC?
I will assure you that the uncertainty that comes with the regulatory framework for the conduct of elections affects the preparation for political party to set the stage rolling. We must try to have some level of certainty. Look at the kind of laws the crook laws that were passed for the benefit of the party in power. Look at the emergency that it has brought. Look at the, in fact, Nigerians should praise the opposition political party, all of them, no, without exception, for being able to, organize themselves within 1 month and submit their register to the Independent Electoral Commission. You look at the statement from the INEC, they stated clearly that no party faulted that deadline that was given within 30 days. So you must commend the political parties for under this emergency and this.
That is highly commendable. That is highly commendable. There is absolutely no doubt about it. It is commendable. And it speaks to the capacity of any party that wants to govern Nigeria or govern any state or even a local government to be able to deliver. But the point that I'm making, Mr. Ameh, is the political parties had to go to the courts to challenge this for one reason: legality. But then Dr. Ubani spoke to the operational and administrative consequences. The transfer window, as Dr. Ubani has graciously agreed to call it, is now thrown open until September. That practically gives INEC less than 6 months to do whatever it has to do to make sure that whoever needs to be on the ballot is the right person in the ballot. I've tried to check the functions of INEC, and you have also spoken to it. There is a need to unbundle INEC. As Dr. Ubani said, perhaps it is for administrative convenience of INEC, that made them say, you know what, let's do this quickly so that we can be calm enough to get some other things done. In case, for instance, there are other elections before the general elections, it kind of helps, INEC to think clearly about the main elections, which is general elections in 2027. I don't know what your thoughts are on that consideration or the concession that Dr. Ubani has made. We agree, statutory responsibilities are there, but then the administrative convenience for the electoral umpire, so that they can produce the kind of results Nigerians expect. What are your thoughts on that, Mr. Ameh?
Thought still remains that we conducted elections previously. Our elections are greatly improved from ballot board snatching, multiple thumbprinting for a long time. And INEC has been able to meet up with some of the guidelines we had that in existing that we use in 2023. That INEC had never seen any challenge, and that's why when they made proposal to the commission, to the National Assembly, they never made any proposal regarding the bridging of this timeline. And so INEC cannot lawfully bridge or limit the framework for the conduct of elections and primaries for political parties. If you are looking for convenience, what INEC should do is that from the day election ends, they should start preparing for the next election. They already have where all the 179,000 polling units are. They already have their staff map out. They have the operational department that can carry it out. What we should consign is to worry about whether these laws that are being made for the convenience of INEC allow for inclusivity, allow for a multiplicity of political party participation, allow for citizens to have right to be able to associate with whatever political party that protect their interests as enshrined in Section 40. Any attempt to restrict these provisions undermines the principles of our grand norm. And what INEC will do, INEC cannot now create a law, either subsidiary on its own, that operates outside the principal law. So what we are saying is that no law can be legal except it follow the dictate of all these provisions. We understand what INEC is going through, and the only solution that Nigerians know that have been given to us since 2008 by Justice Waste Panel, Electoral Reform Panel, 2011 Justice Lemu Electoral Violence Report Panel, and all the other Electoral Reform Panel. Why is it that National Assembly have no courage to go in that direction? Why are they making law for self-serving reasons? Why do they not have courage? Why is the executive does not have such courage to bring an executive bill before the National Assembly? These are the challenges of our time, that those who have been elected to protect the interests of our collective good have decided to protect their personal interests. If they want to do the right thing,
Ameh,
it is not difficult.
Just 1 second before I go to Dr. Ubani. For now, to the best of my knowledge, the National Assembly is still a multi-party assembly, be it the Senate or the House of Representatives. I stand to be corrected. So it's not just one political party there. Even if the one or two others, we haven't heard any voice of dissidence from them, at least to the public. That's one. Secondly, it begs the question whether some members of the CUPP that you are acting chairman of have complained to you or to any of their parties that this is what the majority party in the National Assembly is doing, that they are not happy about. So when you say that the National Assembly is making laws for self-serving reasons, are they also self-serving, those members of opposition in the National Assembly?
You see some of our members, including our immediate past spokesperson. He has been making press statements, and probably some of them gets to you on how some of these laws does not protect the right of the opposition. And for us, when we speak, it is not just for personal reason. And when we talk, it's because you look at the majority in the National Assembly, which has been deployed in a tyrannical manner to undermine the minority voices. There are certain times you can't even have the minority lawmakers to speak. People have been suspended for attempting to speak. You look at what happened to Natasha. I can go on and mention list. It is the tyranny of the majority that is actually further, reducing participation on the floor of the House. And this also extends to the provisions of the lawmaking. That law was passed within 24 hours and signed within 24 hours. See, these are we need to look at the holistic view and see whose interest was this law set ab initio to protect. It is not, if we all sit down and we decide not to talk, our democracy will not deepen. It will not include the way that the children of the poor can participate in it. I became a national chairman, I became IPAC chairman because of the opportunity to participate without any form of restriction, without any form of godfatherism. That is the kind of democracy that I have always prayed.
We're on our way there, Mr. Ameh, which is the reason that you are also, being able to say the things that you're saying. But let me ask you, Mr. Ubani, I beg your pardon, Dr. Ubani, before we take our next break. You've also listened to him. It would seem like there is a lot of trust gap between INEC and opposition parties. And this is not just about the INEC under this administration. It would seem to me like it's been there for a long time, even since the days of Professor Morris Iwu as chairman of INEC. There is always that gap between INEC and the governing and the opposition parties whenever there is a government in power. And I wonder if you think that gap can ever be bridged. And if it can, what needs to happen? Because it is clear that opposition parties do not trust INEC, hence the resort to go to court on this issue.
My brother Ayo, it's not only in Nigeria. All over the world, the umpire is usually not trusted. Especially by those in opposition. They look at the umpire as maybe being biased in favor of the ruling party. And for the African continent, you see the kind of electoral process we've been having. The issue of fairness of the process is always in doubt. The issue of ensuring that you use even technology. Of course, you know how far Nigerian system has come, getting to the level where we are now, trying to deploy a small level of technology in our electoral process. It used to be manual, and it used to be a situation where people would cut away all the electoral materials and, shoot guns and then cause all manner of mayhem. Now we say, okay, can we try to digitize the entire process? At least we started with the issue of accreditation. And then thank God for the new act has now made it now statutory, Then we now say what of transmission is because issue of collation has always been the issue where figures are manipulated. And it's all the process of getting it even to be passed, where they now brought issue of communication if there is communication failure. So the point is that we keep on pushing. That the only way you begin to trust the umpire, whether in Africa or anywhere, is digitize the entire process. Electronic method we really remove the interference of the human factor that actually causes this issue of doubt. You doubt people because you don't believe human beings. they can change, they can do all manner of things, as a result of maybe being under financial pressure and inducement. But when you allow technology and program it in such a manner that it creates fairness and all that, we can move a bit forward. You now begin to create that deficiency of trust. You begin to now eliminate it. But as long as you leave electoral process in the hands of human beings, whether in Africa or elsewhere, you run into problem. While other developed economies have moved further by digitizing the process and relying a bit more on technology, and they've seen the fairness in the entire process. And that's why they're making a lot of progress, and they're probably bridging the gap of deficiency in trust. But here, as long as human beings have been involved and knowing the kind of people we are, nobody will want to trust the umpire. The umpire is always been disbelieved, especially by those in opposition. So let's use more of technology. Let's deploy more of technology in the electoral process, both in voting, in accreditation, in counting, and all that. I can assure you that that gap will be bridged.
I'm taking a look at the front pages of the papers this morning. Of course, they are describing it as a relief for opposition political parties. Another paper says it's a lifeline ahead of the 2027 general elections. Mr. Ubani, I see you laughing there. But I would like to ask what implications you think that this ruling, this judgment has for INEC as a regulator, because it was very clear, the declarations were very clear, and the orders given thereof from the declarations were also unambiguous. So for you, looking at this, and INEC haven't put out this timetable before because it is the regulator, what implications do you think it has for it?
Yeah, INEC has not issued any statement with regards to this judgment. We don't even know whether they want to go on appeal or they will want to abide by the terms of that judgment, But I know it's going to create some level of crisis in terms of convenience and administrative competence, for them. I mean, they have already probably, put their mind towards having everything ended in 10th of May, which is the last date for submission of register of vote for membership. Now it is being extended now to September, and also the issue of primaries. When you would submit the names and all that, they will have to monitor primaries in accordance with the provisions of the Electoral Act that says they must monitor in order to ensure the fairness of the entire process. So it's going to be additional work for them, and it may create some level of administrative inconvenience. That is what I know. But as I said earlier, they have not issued any statement complaining about the judgment, but I know they will go about trying to abide by it, or they will appeal. And maybe the Court of Appeal or Supreme Court may, really agree with their guideline overriding a statutory enactment, because that is what it means. Because the law says this is the timeline within which to submit, but you are now saying I'm shortening it. So I don't know whether they will want to obey that job, but they have no other choice other than to obey, or they go on appeal. But even going on appeal does not mean that the court will set it aside. Until that's set aside, the current position of the law is that the political parties have September within which to submit the names of their candidates to INEC.
Let me ask you, Mr. Ameh, you've been watching what's been happening within political parties and their primaries, and the amount of complaints that have come out of these primaries have been difficult to ignore. For you, given the two methods allowed political parties to conduct their primaries, well, some people have said, well, this, as far as they're concerned, is power to the people that make up political parties. For years, it was seen that they've always opted for the convenience of either consensus or indirect primaries. Very rarely do we see political parties pick the option of direct primaries. So for you, taking a look at what has happened so far amongst political parties, what's your reading of where our democracy is, particularly internal democracy amongst political parties?
I think amongst political parties, there's a lot of stiffening, a lot of overbearing authority. If it's party in power, the people in power determines how the effects of the parties are run. Unlike what we had in First and Second Republic, where party leaders were strong enough to manage their affairs and then look at the regulations and internal regulation and processes on how to determine the outcome of their organization. But what we have today is that we need to be able to see that this overregulation also affects the internal workings of political parties. You are now saying direct and consensus. By removing the indirect. The direct primary is very expensive. You know, if you're conducting it across all polling units or all wards across Nigeria, it's very expensive. So parties should be allowed to have choice. And this overregulation also take away the functions of the political party and put it in the hands of INEC. And that undermines their right to sit with their organs, whether from the State Working Committee, National Working Committee, Zonal Working Committee, or the National Executive Committee and the Convention to determine whatever module that will be more appropriate for the conduct of their primaries. And so these are all these overregulation that I am worried about.
You think it's overregulation? Well, I mean, while some people will say, well, you have limited the options, but given how political parties have now conducted themselves, is this something that leaves you happy as somebody who has been in the political space for a while?
I'm not unhappy with the political parties. They are trying under the very harsh circumstances.
They're trying.
You must allow organic development. All this process of trying to hash a egg before the date is not really. You must allow organic growth and allow political parties to learn, make mistakes, you know, and grow organically to be able to manage their own affairs. You don't strengthen an institution by overregulating. What you do, you allow the institution to continue to grow, to continue to make a mistake, and not that every time the National Assembly will make laws for the political party internal process. Yes, they are supposed to make laws. Those regulations are already captured.
But the political parties rarely have any internal processes.
No, they do.
Most times what we see is, as you've said, the overarching or overbearing influence of people who are leaders within this political party.
Because those who have managed the presidency over the years have used their party to be able to make other party weak. Because you talk about being in opposition today or in 2008, and you go to members of the public and say, come and pay your membership of 1,000 naira monthly for 1 year, which is 12,000. They say, why are we paying? Why parties in power are sharing wrapper, are giving T-shirt and giving us rice and giving us face cap and giving us milk? Why are we paying to your own party? So this damage of the internal fabric and dynamics in the party is not the fault of the opposition. It's the fault of those who have dipped their hands in public offers to gain an advantage over other parties. So you cannot expect the members of the public, because perception itself is stronger than reality. So you cannot expect the member of the public to now believe that there's a party they should be paying dues to.
Yeah, but so, how then do they intend to effect any change if at the level of their own political parties they cannot even effect any changes?
That is where
they can't even show that they are different from other political parties.
That's where, look, let me tell you, Youth Party. The first chairman is a very good friend of mine, Suleiman. When parties were deregistered, he went to court and obtained the judgment of the power of INEC for using Section 2258 to deregister political party. He came back and was registered. The current chairman has also gone to court to contribute to our legal jurisprudence, all the legal things we need to have our party management, and as one. So parties are trying under the very harsh democratic circumstances to find ourselves.
No, so maybe you should say Youth Party is trying.
Not Youth Party, I can mention one party. A lot of parties are trying. So even if you see internal conflict and people are even having issues, it doesn't mean that the party is going to die. These issues, you know, deep to bring conversation, bring discussion. Even between husband and wife, they are quarrel, and they settle eventually. But parties in power should stay off for interfering in the issues of political parties.
Well, Mr. Ubani, I know that you're a Nigerian just very much as I am, and oftentimes, you know, we don't really see the difference between 6 and half a dozen. Have you really, you know, when you take a look at what is currently happening with the primaries of political parties and the fallouts we're hearing in some of these political parties, what is your own reading of what is happening so far?
Well, the Electoral Act gave opportunity for election through direct and consensus, and most political parties are adopting the consensus, which most times have shown that it is actually the preference of the godfathers, whoever they like. And in APC, for instance, the president gave the governors the power to be the one to make that choice. And I don't know whether they're regretting, because many of the senators that I know in the National Assembly are not coming back, because the governors have taken a position that they are not coming back and all that. And that is by consensus. And we have seen the abracadabra too in the counting process. You remember one particular one, I don't know whether you watched it, 1, 2, 3, got to 8, then 1,000, then the next is 2,000 and all that. And the result is not announced there. The result is taken to the political party's office to announce. so that even if you participate in the entire process, the fairness of that process is clearly in that. I'm talking about the direct. Then the consensus is Godfather's choice, whoever they have chosen. And so a lot of people are really aggrieved, with the arrangement presently going on. And that's why this particular judgment is like a lifeline to so many politicians that have actually been excluded by the entire process. They don't have opportunity of jumping to another political party. But this judgment has actually brought high level of relief, to the political class. And that is the truth. That's why when I wrote an article last night, I made sure that I distributed it as widely as possible to these politicians to look at what opportunity God has once again created for them to look for a lifeline support elsewhere if they are denied opportunity in wherever they are. So this judgment is clearly fundamental. But I am saying this issue of consensus is autocratic. I've seen it in practice. I know some of us have been victims. We've seen what is going on presently. Some of our clients and all that. How before you know it, the decision has been taken that you're no longer part of the people that will represent the political party because somebody do not like your face. And if you are not in the good books of the Godfathers, you are in trouble. You're in trouble in the process. So the internal democracy of political party is still in doubt, especially with this present arrangement that allows consensus and direct. Direct, we see the kind of counting, magical counting that usually take place in the entire process. So it's still creating some level of doubt. We don't know what we're going to do in order to bridge this gap and probably improve the system. I have not seen much improvement, with these primaries, especially with the consensus arrangement. I have not seen much improvement in terms of internal democracy. I have not seen issue of people having a choice, people coming in to make a choice, even at the primary level, before the election proper. I have not seen that choice being allowed to be made by the people.
Well, speaking of writings, I think that Samson Itodo, who is the executive director of YAGA, already also put out that warning that elite imposition has the capability to overthrow the people's democratic will. And there were questions as to how it is that we can continue to expand our options. Because really, at the end of the day, what political parties do is that they throw up options for us to be able to say, either you take this, or you take this, or you take that. And when their own internal processes are flawed, then they start to limit the options of the people even before they come forward. So there are big questions for us, I mean, who are watching what is happening within this political space, for the electorate, so to speak. What other things do you think that the electorate can do to force the hands of political parties to be more democratic within their own internal processes? Because really, as you said, what we saw with the counting process in some of these direct primaries was very heartbreaking, was very, very disconcerting for a lot of Nigerians. You mean this is what happens in political parties? What do you think that we can do then?
Key participation of the people is very important, for democracy to really thrive. But over time, the space always, they shorten it and they try to, probably even deny access. I see no reason why I should not participate in choosing who is going to be my candidate in my political party. I should take a part in it. That is participatory governance. If I don't have that power in choosing who is going to represent my political party, then you have really shortchanged me. And most times people are being shortchanged. So your question is, what do? We must keep on pushing. We must not in any way give up hope. We must insist that things be done properly. No matter what, no matter whose horse is God, no matter how powerful you are, Nigerians must have this spirit of pushing for the right thing to be done, because we cannot have a country that we should be proud of when we cannot have this sense of doing the right thing. And most times it's the wrong thing that we do, and it's the wrong thing we praise, it's the wrong thing we recommend, it's the wrong thing we see operational in Nigeria. So the issue of pushing, we must begin to recruit more people. And I like the kind of awareness on the part of the young ones, nowadays, in pushing that we must have a country we should be very proud of, and that we must begin to have things done properly, because we have seen other nations do their own things and they are getting it right. So why are we always doing the wrong thing? And there's no way we can get it right if we always insist on doing the wrong thing. So issue of pushing for right things being done is what we must not in any way give up. So that's my advice. Let the young ones keep on pushing. Let all those who believe in this country keep on pushing. We must not give up. We must not give up. Both during the electoral process, passing the law, we must keep on insisting that they should put the correct provisions in the law. And then when it comes to implementation, we must also, I like what the Youth Party did. If other political parties have gone to sleep, others have gone to sleep, but Youth Party said, no, And I am aware that the law itself is being challenged also. Some of the Electoral Act provision is also being challenged by certain persons and other. Public interest litigation, strategic impact litigation is one of the ways you can really develop a country, have a country that is governed by rule of law, have a country that you are very proud of, have a country that is free from corruption. Public interest litigation, is very important. And I am really recommending it to all Nigerians, In fact, I am pushing for a bill now that can allow issue of local standard to be properly defined, because they use local standard to deny access to majority of Nigerians that want to come with strategic impact litigation. But we are now saying, let's define who is a public interest litigant. And whenever you come before the court should not look at the messenger, but look at the message that have brought you before the court. That is how India has made tremendous progress. Kenya, even South Africa, they have broad opening in terms of local standard. So public interest case is where we have to go. So anytime you feel that government is not doing it right, go to court, and let's have judiciary that is also independent and very bold enough to say this is wrong, this is right. And I love what Justice Omar did. It was boldness in action, and there is no other way for us to move forward other than things like this. That would be my take.
Well, the coming days will certainly stipulate or will show us what implications indeed this particular judgment has, especially as the media, yes, we're interpreting it as a lifeline for opposition political parties. Gentlemen, we have to thank you both for coming on Sunrise Daily this beautiful Friday morning. We've been speaking with Dr. Monday Ubani, Senior Advocate of Nigeria, who joined us virtually, and Chief Peter Ameh, who was the Acting National Chairman, Coalition of United Political Parties, the CUPP, who joined us here in our Abuja studios. Thank you once more for coming on the program.
Thank you.
Well, that's where we draw the curtains this beautiful Friday morning. Thank you so much for letting us be a part of your day. We hope that the day remains just as cool as it started out and productive as well. Thank you for watching. I'm Maokwe. Ogun yourself.
Well, as has been said in that judgment, the transfer window is still open. I don't know for how long and who else is still transferring. Let's see what happens in the coming days. I'm Ayo Makinde. Enjoy the rest of your day and a beautiful weekend.